This is KUTV Primetime News with Irene Mwangi.
Thank you for staying tuned. As we promised, it is that time for our discussion tonight, looking into the BBI court battle. Joining us tonight is an advocate, Mr. Elias Mutuma, who is joining us tonight to give us a perspective concerning what is happening in terms of the BBI court battle and the appeals that are happening right now in the Court of Appeal. Many thanks indeed, Mr. Elias Mutuma, for joining us tonight.
Thank you, Irene. Thank you for having me. I hope you can hear me.
Yeah, we can hear you quite clearly. Now, let's start the discussion, and we'll start from the point where the Attorney General, Paul Kihara, of course, withdrew the stay order application at the High Court to the Court of Appeal minutes after the High Court judge bench certified the matter as urgent and actually said that they were set to make the ruling on the 26th of May 2021. What do you make concerning that particular move by the Attorney General and the timing?
Number one, I think it was a mistake from the very beginning for the Attorney General to imagine that they would secure stay orders from the same bench that found a lot of irregularities in the process. So I think that realization must have come to them a little bit late, but it's something that ought to have been realized by them as and when they made that decision to appeal. So they did not stand any chance before the five-judge bench. I think that's what they realized, and that caused them to withdraw, to avoid an embarrassment on their part.
All right. And then can there be really a stay order on a declaration that is made by the High Court? There has been a discussion, and legal experts have been told to put it quite clearly whether we can have a stay order concerning a declaration that has been made by a court. Is that avenue really possible?
For the benefit of the viewer of KUTV, a stay order is a suspension of a positive order that has been issued by court, so that once a stay is it prevents the enforcement of a certain order. So when you look at the entire judgment that was read by Professor Ngugi and the other four judges, there wasn't any positive order that was capable of being stayed or suspended. The court only issued declarations. So I wonder what the IG is looking for when they really want. There is no positive order that is capable of being stayed. Those are just declarations that cannot be stayed, because what do you suspend? You cannot suspend a declaration. Yeah. So I think it is it's just a miss from the very beginning.
All right. Now let's look into the timing of this particular appeals and whether we'll be having constitutional changes before the next presidential election or the next general election, so to speak. Looking into the timing, we are 14 months before the 2022 general election, and you can only change the constitution before a year, that is within before 12 months before the election. We're looking into the timings. Are we seeing the BBI steering committee seeing a success in terms of amending the constitution before the polls?
Number one, Irene, it took us a total of 5 months to have a judgment from the High Court because we had a total of 8 petitions that were consolidated into one. So if we were to proceed to the appeal, presuming that we will proceed first to the Court of Appeal, it will take us a few months before we even get a final judgment from the Court of Appeal. That, I believe, will not even be the final stop. We might again end up the Supreme Court, again eating into another 2 or 3 months. So the idea is that we can have a finality of this matter in terms of court pronouncements. If we were to proceed all the way to the Supreme Court, and I believe we will go there, it will be not less than 6 months from today. So your guess is as good as mine, whether 6 months from now we are still capable of going to a referendum, assuming that the Supreme Court is going to agree with them, and that would be in the unlikely event. So I do not see us proceeding to a referendum based on the timelines that are there to ensure that we have a judgment before time and proceed to a referendum. I do not see that happening.
All right. Now, should this matter be certified as urgent in terms of hearing and, of course, making a ruling on the same? Should we have the Court of Appeal now overturning the decision of the High Court in any chance? Does it mean that now President Uhuru Kenyatta's quest to change the constitution, of course, in conjunction with ODM leader Raila Odinga, is now something in limbo?
I think their goose was cooked when the High Court bench read that ruling, honestly, because even if the Court of Appeal, like I have said, certifies the matter as urgent, we have a whole process ahead of us. Preparing the record of appeal is not a walk in the park. Getting responses from the respondents is also not a walk in the park. Filing submissions and hearing all those grounds of appeal that will be adduced, I hear 14 or 15 of them.
Right.
I don't think that it is capable of giving a judgment in a matter of weeks. It will take them at least 2 or 3 months. That is, even if they would want to expedite the matter, they will not be able to do so effectively within a very short period of time. Yes.
All right. Now, looking into the ruling of the High Court, of course, they pointed, it was really a major ruling. Now, will you advise the president to start the process from the start, either using the parliamentary initiative? Do they now go back to the drawing board and leave the court battles that they are angling on?
If the target is 2022 elections, I don't think they have that luxury of time anymore, because again, even if you were to start a parliamentary initiative, we have a whole process of public participation. We have a whole process of first, second, and reading of the bill. And then you cannot just introduce a bill that was a popular initiative and try to convert it into a parliamentary initiative. That will still take time. So if then the target would be 2022, I would say that it is too late for them to begin afresh. The best thing is for them to just accept and move forward. But if 2022 is not the end game, then there's still that chance, because we then have time to peruse through the bill, go through public participation, go through civic education without having 2022 in mind, so that we can have this referendum months later, beyond August 2022.
All right. Now, Wakili, there was that proposal by ANC leader Musalia Mudavadi, who was talking about the IPPG talks being the next possible avenue. Now, looking into the quest that we are having and the push and pull concerning this particular issue of BBI and the constitutional changes, of course, some term it positive, others term it detrimental and not really a priority at this particular time. Perhaps, could the IPPG talks be the shortest avenue possible?
I don't think I got your question. Would you kindly repeat?
All right. Now, the ANC...
your last part.
The ANC leader Musalia Mudavadi had given a proposal that instead of going through the popular initiative, maybe we'll have the IPPG talks as a way of creating these particular changes. Now, from where you sit, do you think the IPPG kind of way might be the shortcut in terms of pushing for these particular changes?
Now, IPPG or not, Irene, we only have two routes to amend our constitution in Kenya. One is a popular initiative, the other one is a parliamentary initiative. So whether they go through Musalia's proposal, they will still have to go through either a parliamentary initiative or go back to a popular initiative. So I do not see, even if they were to engage political parties, then what would they be the end game? Would they still have to come back to either a popular initiative or a parliamentary initiative? So that does not help. That does not in any way afford them any time that has been lost.
All right. Now, Parliament has been blamed to whatever is happening in the country right now, and in particular concerning that particular High Court ruling. Do you think the absence of the referendum law might have costed this particular process from the start, given that we do not have a referendum bill here in the country?
Not might have. Actually, that was one of the grounds that we raised in the High Court, and it was accepted 100%, in that we do not have not just a referendum law, but we do not have any legal framework of any sort governing, number one, the collection of signatures, the verification of signatures, the manner of debates in the county assemblies, the manner of debates in the National Assembly and Senate, how you forward that bill to the president, what is the threshold of the public participation. All these make the judges find out that really we do not have a legal framework to govern, and it was left to the specific players, IBC, National Assembly, county assemblies. They would employ their own measures and guidelines without any form of uniformity. So the absence of a national referendum law and also the absence of a general legal framework contributed toward the judges declaring the whole process unconstitutional.
All right. From where you sit as an advocate of the High Court, do you think President Uhuru Kenyatta is lacking in terms of legal advisors in his circle and in his leadership that might have costed the process from the very start? The Attorney General Paul Kihara has been blamed for letting down the president in terms of some legal loopholes. Do you hold the same opinion?
If indeed then the president listens to his legal team, starting with the Attorney General, then it means that the Attorney General is a very incompetent person, and all other persons that have been advising the president legally. Because you cannot have 5 judges declaring 21 points a legal mind in your team. So either the Attorney General or the other legal members of his team are very incompetent, or that the president is ignoring their advice. That's what I would say.
All right. Now, looking into the judgment, of course, they termed, some have termed that what the 5-judge bench gave as a ruling was a disrespect to the president and the office of the presidency. From where you sit and looking into the judgment, do you think the 5-judge bench might have usurped their powers in giving the ruling and, of course, disrespected the office of the president and the presidency?
Sorry, Irene, I think I lost you for a moment.
Yeah, there was a problem here, network challenges. I'm asking, looking into the ruling by the 5-judge bench, some have termed the ruling as a disrespect to President Uhuru Kenyatta and the presidency. From where you sit, do you hold the same opinion, or do you think the 5-judge bench was well in place to give that particular ruling concerning the president?
There's only one reason why people are saying that the judges were rude or disrespectful to the president, merely because they refer to him using his first name, Mr. Uhuru Muigai Kenyatta, but they do not. There was a petition that was filed against the president as a person, and it was referred in his personal capacity. So if then the judge is referred to him as Mr. Uhuru Muigai Kenyatta, it is because he was being sued in his personal capacity. And you know what, Irene? Even after being sued, the Attorney General or any other legal counsel from the President docket did not bother even to defend the president. So that particular petition went unchallenged. So it is for that reason that the judges found that the president, or rather Mr. Uhuru Muigai Kenyatta, in his personal capacity, had actually violated the Constitution. So it was not disrespectful in any way. It was just because he had been sued in his personal capacity, putting his paper aside, of course.
All right. Now, looking into the BBI bill, of course, there are some aspects that might have been termed as positive, others as negative. Do you think there are some proposals in the BBI report or the constitutional amendment bill, especially concerning the issue of revenues to counties, that might be salvaged, of course, using the parliamentary initiative, given that it is not as tedious as compared to the popular initiative? Do you think that might be the route to go moving forward, given that things might have hit a snag should the Court of Appeal not overturn the decision by the High Court?
The issue of allocation of more resources from the council has been kind of being dangled at the face of Kenyans. The truth of the matter is that we do not need to change the law to achieve that threshold of 35% at the minimum. Because when you look at the current constitution, it talks about a minimum 15% that goes to the counties. So there's nothing that prevents the President, National Assembly, or the Senate to approve a budget of 35% if we have that kind of money in our coffers. So we do not need a popular initiative. We do not need a parliamentary initiative. We do not need BBI. It's just a matter of implementation. So it's just a matter of policy. So I do not even see why the promoters wanted to use that as a bait, because we do not require to amend the law to achieve that.
All right. Finally, what can be your final words concerning this particular issue of BBI court battles? Kenyans have expressed opinions that maybe the system, quote unquote, might have their way concerning this issue of BBI. Others are pessimistic and others optimistic concerning the process altogether, depending on where you stand. What can be your final words concerning this issue, or this battle of the BBI process?
Number one, the judgment by the 5-judge bench was monumental. It was a bold one. It was a Wanjiku judgment. It was not a win for us as advocates who are appearing for various parties. It was not a win for any political party or any faction of government. It was a judgment that came to the defense of the Constitution. And I would just add the government not to be bashing judges every time they lose a case, because it shows how disrespectful they are of one arm of government. Remember, judiciary is an equal arm of government that is entitled to proceed and conduct its business in accordance with the law. So then it portrays the government in very bad light the moment they start, bashing judges left, right, and center just because they feel they are not happy with it. And guess what? If BBI was really for Mwananchi, and we have seen the reactions from Mwananchi based on that judgment, why can the government say we have actually seen that this thing is not working? It is not in any way being embraced by Wanjiku. So they should just accept and move on. And they have appellate processes. If they succeed on appeal, well and good. If they do not, there is nothing personal. Amending a constitution is not an emergency. It is not of personal benefit. It should benefit Wanjiku. So if then the court finds that the process was flawed, we can wait until the next time when we have that opportunity.
All right. Thank you so much, Mr. Elas Mutuma, for giving us your perspective concerning the BBI court battles in the country right now.
Thank you so much, Eric, for having me. Go ahead.
All right. That has been Mr. Elas Mutuma, of course, giving us a perspective concerning what is happening right now, the circus concerning BBI in the Court of Appeal that we are rating. He represented That Way Alliance Party in one of the petitions that was presented in the High Court. We are taking a short break, but we'll be back with more on what is happening beyond our borders. See you in a moment.